welcome to everybody. Good morning, depending on where you are in the world, if it's morning with you. At the moment, we've got 37 people on, including the home team. We're due to be having about 85. It may be that one of our speakers can't get on, but Chuck, who you should be able to see, Chuck Kanafi, if that's the correct pronunciation, Chuck, is going to cover for his co-speaker if Paul can't get on. So apologies in advance for that. We normally invite people who are first timers to introduce themselves. So I've got my list. So if anybody's already on, if we can start with that, please. And you'll need to unmute yourself. Firstly, Will Chalmers, are you on, Will? Not yet. Okay, moving on then. Charlotte Duran.
Yep, I'm here.
Hi, would you like to introduce yourself?
Hi, yep, I'm Charlotte. I'm currently a mediator and paralegal at Regan Pegg Solicitors in Birmingham.
And why have you come to mediation?
Just, it's something that I qualified in last year as an alternative to sort of pursuing a career at the bar. And I think given COVID, people are having to look elsewhere for ways of resolving disputes. And so it's, I think, the smart way that everything's going to be moving towards from now on.
Okay, thanks very much for that. Welcome. Then I have Sam Narula. Are you around, Sam? Maybe not yet. Jualine Nicholas. Jualine, are you there?
Good morning. It's Judeline there, Dave.
Sorry, Jualine.
That's all right. It just catches.
My apologies.
Not a problem. Hi, well, good morning, everyone, and thank you for the invitation to join you. I'm actually a learning and development specialist, particularly focusing on issues of equity, diversity and inclusion, which we know can be and be expected. And I had the pleasure of working with Terry last year. Hi, Terry, on the National Mediation Awards, which was incredibly exciting getting to that path. I think Terry will agree on that, but it was great seeing everyone contributing. And I also sit on the employment tribunals in the UK, looking at discrimination cases and the role of mediation that can play there. And I just want to keep abreast of everything and keep up to date. So that's why I'm here. Thank you for the invitation.
Great. Where are you based?
I'm in Norfolk.
Norfolk, right. Okay, thank you very much.
Thank
you. Then I've got Graham Perry. Are you on, Graham? Okay, then Dale Roberts.
Good morning, everyone. Thank you for the invitation. So my background isn't legal, it's commercial, specifically digital business, most often running European teams for US-owned global tech companies. In Paris, certified in 2020, just in time for lockdown. Richard Shraver, who I suspect many of you will know, providing support for his Zoom meetings, but giving me the excellent opportunity to observe and learn in a good mix of commercial estate, clinical negligence, cases. And I'm based in Woking.
Woking, thank you. When you say certified, do you mean
I mean
accredited?
accredited, you're absolutely right. Although I have been certified too.
Good, okay. I'm going to just answer a call. So if the next person who is a first timer could mention their name and say hello. Anybody there? Jenny Taylor?
Hello.
Hi.
I very nice to be attending today. I actually work internally as an HR director, starting to do more internal mediations and starting really my training on this. So I've done some training, and I'm looking to further develop that and do some more.
Thanks very much. I've got Phil Tutil. Hello, yes. Yes, it is, yes.
I might just take this opportunity, given that Phil doesn't seem to be there. I'm Ablo Callahan. I'm a barrister based in Cardiff in 30 Park Place. I do mainly public law and civil in terms of my practice, and more recently, in the last few months, I undertook the mediation training. And I'm looking for the opportunity to observe some mediation so that I could fully complete that training and start some mediations of my own as well. But in terms of areas, I'm particularly doing in public law, education and court of protection, and civil matters as well. So hopefully that's filled up a bit of time during that call, even though I don't know if I was on the list or
not. Thanks, Alba. Will, I think, Will Chalmers, are you?
I'm here, Dave. Hello, good morning, everybody. Do you want me to say about the International Week, Dave?
Well, if you can just introduce yourself for the moment.
Okay, yeah, no, fine. So we're coming as a duo this morning. I'm Will from Mediator Network, and this is my colleague Lisa. She's a business development manager here, and we're helping mediators with basically building practices and getting work and all that kind of thing, really. And we do lots of incentives and promotional activities. So Mediator Network is quite active at the moment. So if anything you want to get involved with community-wise, in terms of mediation community, come and knock on our door as well.
Thanks, Will. Anybody else who's a first timer who hasn't had a chance to speak yet?
Yes.
Who was that, please?
Victoria.
Oh, hi, Victoria. Yeah, far away.
I have attended a breakfast meeting before in Fleet Street, but that was once. But this is my first time attending on Zoom.
Mm-hmm.
My name is Victoria Mitchell. I am currently studying Master of Laws, Legal Practice Solicitors at BPP University. And I learned mediation skill with London School of Mediation a few years back. And I was inspired to become a mediator because of something I read somewhere in the Holy Book, that blessed are the peacemakers, for they shall be called the children of God. And I love to help people resolve their problems. So right now I'm trying to get into mediation better. So I want to be consistent in attending these meetings.
Thanks very much. Where are you based, Victoria?
I'm in London.
In London, right. Thank you. Anybody else who's here for the first time or who's been before but hasn't been able to introduce themselves before?
Hi, I'm Kellyanne Salisbury.
Hi, Kellyanne.
First time attending this. Thank you very much, Dave, for your messages and constant updates. Really helpful. I'd like to come along to this just to keep abreast, as somebody said earlier. I was accredited in 2019. I know some of the people on this in this meeting. I won't call you all out by name, but you know who you are. I was a solicitor for many, many years. And during that time, I realized that mediation was the way to go. I wasn't a litigator. I was a corporate lawyer. But I found myself mediating quite naturally at that time. And afterwards, I went into various other industries, set up my own business. I have also lectured, and I also write. So I've got a few areas that complement, I think, mediation in some ways. And I find it fascinating and just a really good method of helping people become unstuck. I also do a mediation podcast, which seems to have had some very good response. So I appreciate this this platform. Thank you.
Thanks. Where are you based?
London.
Shelley?
Also
In
London.
Yeah,
Mhm.
good. Anybody else? No. Okay. Well, I've only got one speaker to introduce at the moment, which is Chuck. I think you're based in Berlin at the moment, are you, Chuck?
Yeah, that's correct. This
And
Berlin.
That's a virtual background, I'm presuming.
Yeah. Actually, this picture is a very famous picture of Berlin. You find it all over. It's taken from the roof of a residential building, and most tourists to Berlin come to this building to try to go up to the roof to take the picture. And it drives the residents of the building absolutely crazy that people are ringing their bells at all hours of the day and night to go up there and take it. I just downloaded it from the internet, though. I'm a nice guy.
Well, there's a business opportunity there, I think. So can I leave you to introduce yourself and kick off? Chuck has kindly said that he'll speak for about 45 minutes and then about another 15 minutes for Q&As. So if you can keep your questions until the end, and then we'll put you live on to ask any questions or make any comments. Over to you, Chuck.
Okay, thanks. Let me just take the view so I'm not looking myself directly in the face. Thanks, Dave and Martin. Thanks for giving me also the opportunity to be here. First, I want to apologize for Paul Sandford, who was supposed to begin this morning's talk, but he lives in a little village, and evidently all of the electricity is out for the village. So he doubts that he's going to be able to make it, but if he does manage to pop in before time, then I will of course yield the floor to him. Myself, yeah, Dave said Chuck Kanafi. Some of you here know me. Some of you here are connected with me in one way or another. I am based in Berlin at this time. A little bit of background: I was born in the United States, so you can hear my American accent. Left the U.S. when I was 18 for Israel. Studied law and was called to the bar in 1990. My first bar. I'm also a member of the New York State Bar in New York, and began work as a prosecutor, as a public prosecutor. Did that for a few years and promptly got fired because I was too empathetic to the accused, it would seem. My bosses didn't want me as a prosecutor any longer. So that was the beginning, I think, of my collaborative journey and and seeing the other side and seeing all sides. Not good for a prosecutor, but quite good for a mediator. The next 25 years I spent in the Israeli Foreign Service. I eventually, my last postings were, I was ambassador to Ghana, I was ambassador to Eritrea, and I was also consul general for Israel in South India in Bangalore. And during that, during my time in Bangalore, I decided to buy the whole midlife crisis package. So I got a heart attack, I got a divorce, I quit my job, but I didn't get the red Ferrari. And I don't know how that happened, that I didn't get the red Ferrari. I'm still waiting for it to come, but it just didn't happen. So I'm living with a bicycle instead.
Chuck, which came first, the heart attack or the divorce?
Pretty much at the same time. If you're talking exact timing, I would think the decision.
No, we don't need to exact time.
Yeah, slightly before. But why do I mention this? Besides the fact that it points out my age a little bit, is that our divorce we decided to do through mediation, my ex-wife and I, rather than doing it through litigation for a number of reasons. And it was such a positive process for us, actually, that afterwards I went to the mediator and I said to the mediator, "Hey, can I learn to do this? And he was like, yeah, we've got a center, we can teach you, et cetera, et cetera. And so I did the basic course and the advanced course, which I'll speak to shortly. These courses in Israel. I fulfilled all of the qualifications to be a court-appointed mediator, but never did it because I wound up moving to Berlin. I moved to Berlin 2 years ago to be with my beloved. We just got married about 2.5 months ago. And just again, for those of you who are considering whether family mediation is a good thing or not, or considering whether to be family mediators, my ex and her boyfriend were at our wedding. So that's how well it actually works if you have a good mediator, I suppose. The reason the reason we begin to talk here, and now I'm actually going to begin my presentation. I'll start my screen share. I think, Dave, you have to open me up to screen sharing. It's not letting me. Ah, okay. There we go. And okay. There we go. It's I've been aware, and as I said, I'm affiliated with some mediators in the UK as well, and I'm aware that the question of mandatory, I'm going to call it mandatory mediation, although of course you can't mandate mediation, you can only mandate showing up at a MIAM. And that's what's done in Israel. But it became, it's been an issue. It's been a hot topic for a while in the UK. I'm aware of that. And then, of course, the report from the Civil Justice Commission and the Master of the Rolls recognition of that have made it even more of a hot topic. I wanted to bring some of the Israeli experience to that, just so that you can be aware of what's going on in other countries, how successful it is, and so forth. So I'll begin giving you a little bit of a historical background, how we've come to the situation as it stands today. I want to act on a number of assumptions, which are not necessarily axiomatic, but they're going to be the basis of my talk. The first is that mediation actually does decrease court backlog. And I don't know if that has actually been empirically proven anywhere. In Israel, it has not yet, but you'll see why shortly. Second, that mediation can't be imposed. Mentioned that before. And the third, which is kind of, I guess, a little bit of a corollary, and it's not necessarily obvious, but if there's mandated mediation, then some sort of qualification is necessary there, so that the courts are referring to people, or the justice system rather than the courts are referring people to who are qualified in some way or another. The mediator training in Israel, and as I said, there is a qualification. Practice consists of 3 basic elements of training, which I will cover again later, of having a practicum, which is an advanced course in mediation, which includes mediating real cases under supervision. It's actually part of the course. You can't be qualified until you've actually done that, and an assessment at the end, both oral and written, and some additional experience. Family mediators have additional requirements for further training. That is to say, they have to have a second course and a second practicum. They also have to have further experience. The situation as it stands today in Israel is that there's obligatory mediation in the family and religious courts. I think there's something similar in the UK as well. That is to say, if you open proceedings there, you have to go to mediation first. Mediation in civil and commercial matters has become obligatory as of the 1st of January, 2021. They just entered into force. And in small claims, they are not necessarily obligatory, but the small claims judges do tend to refer many cases. That is to say, if it's an open and shut case, let's say a traffic incident with insurance and no fault insurance coverage, it's not going to be sent to mediation, but pretty much everything else is. I'd like to go to the background for a moment. Mediation began to be thought about, let me put it this way, by the Chief Justice of the Israeli Supreme Court in the 1990s. and he was a thinker, he was a theoretician, actually was an academic for his entire career until he was appointed to the Supreme Court, which is the highest court of the land in Israel. And instituted a lot of reforms in the court. Why do I bring this up? Because the recognition of the importance of mediation, or the qualities of mediation in Israel, was pretty much and still is a top-down process. That is to say, it's the system telling you should mediate, and there isn't really a lot of pressure from underneath to mediate, especially in terms of private mediations. But what's interesting about what Justice Barak said then in the 1990s was basically that mediation was a good thing in and of itself. It was a good system for delivery of justice. It was an important part of the dispute resolution universe, and not necessarily to relieve backlog. And in fact, he mentioned at one point that relief of backlog was the way that the system would sell mandatory mediation to the judges, and then the judges would become advocates, would become zealous advocates of mediation in order to decrease their own backlog, and sort of through the back door, this advantageous process of mediation would become entrenched in the Israeli system. As I said, mandatory mediation became mandatory in family matters in 2014, and in civil matters only this year. And in that period, the stated objective in all of the legislation and all the proposals of legislation before first reading and so forth, really the only objective that was stated there was decreasing court backlog. Just so you understand, I'm going to give a little statistics. I'm not going to dwell on this, but approximately 850,000 new cases are opened in Israel every year. It makes Israel the third most litigious country in the world per capita. And about 880,000 are closed, where the standing backlog from year to year, which keeps staying there, is about 440,000. So you're talking about almost 50% backlog. The time to close cases is very, very long. Civil cases I'm speaking of here, between 12 and 24 months. And what's interesting there is that more than 80%, I exaggerated here a little bit, 85%, but more of 80% end without judgments. That is to say, they may end with a consent order, but basically on the basis of a settlement. To make it a little bit easier to understand all these statistics, and the link here, which you will also receive as a handout, the link here is to a document in the Hebrew language. Unfortunately, it's not published in English, but Google Translate only mangles it slightly. But if we just look at it here, I have this, I made up this kind of this chart. So if the gray area is the total cases, and within the red area are those which are settled, at this point, 100% of those 100% of the total cases are sent to Menahem. Out of those which are sent to Menahem, 50% then continue on to mediation. 50% after the Menahem say, well, this isn't for us, we'd rather just litigate it out. Of those 50%, 80% of them settle eventually. But the actual mediated settlements within those that have gone to Menahem is about 60% of total. So it's a 30% of the total number of cases are actually settled through mediation as a result of mandatory Menahem. That's pretty much the number. So those cases are then settled. Another 20% or so have been through mediation, but didn't settle with a mediated agreement that they settle later on. And then out of those, another 40% eventually settle without resort to court-appointed mediation at all. So having given you that background, I'd like to talk a little bit about the general legislative framework. First of all, private mediation. I should mention this, I think, beforehand. Israel is a common law system. We inherited the British legal system in 1948 with independence. Over the course of the years, it's become a little bit more statutory. It's a little bit hybrid. Contracts law, for example, torts law, and so forth have been codified in statute, but there's still a lot of precedent, and the idea of precedent going on. So the basic principles of common law are still there. So private mediation is of course always allowed in terms of the law of contract. It's a private contract between private individuals, and can be enforced as such. I think that goes without saying. In 1984, an addition was made to the court where the court was empowered with the consent of the parties to refer any matter to mediation. That was not very successful. It was almost never done. As I said, that's statutory, so it may be referred. Judges tended not to do that, and there was not really kind of a structure for that. At the time, also, this was before any qualification, so the court could say go mediate, but there weren't any necessary qualifications for those mediators. I'm going to skip the definitions. It's stuff we all know pretty much. However, once mediation began to become mandatory, either in family matters or a pilot was run from the late teens in the civil courts. As I said before, you can't really have mandatory mediation if you don't have mandatory qualifications, and so that those regulations were written in 2017 about the qualifications. A mediator, for a civil mediator, a general mediator, needs to have an academic degree and 5 years of professional experience, do a basic course of 60 hours, do a practicum, which is 60 hours, and 6 actual cases, which are referred from small claims. They do it under supervision. Just for example, for my course, the first one was with a qualified mediator. The next 5 or 6 of them were as co-mediations, and then the last 2 were solo mediations, again with a trainer in the room. Beyond that, after having finished that, you can qualify as a small claims mediator. If you want to be appointed from magistrates court or district courts, you must do an additional 12 cases and report on them. There's written an oral exam, there's a licensing fee, and it has to be renewed every 5 years. I myself, as I said, I fulfilled all of the conditions, but I never actually joined the roster because I don't live there, and getting court appointments wouldn't really be very relevant for me. Family, I think I'm going to skip right now, as just kind of decided not to speak about family today. Regulations came into force, as I said, in the beginning of January 2021, of mandatory MIAM. To understand just where that fits in terms of jurisdictions and so forth, I've done rough translations here into pound sterling. Small claims court are any case up to about 7,000, 7,500, and in those cases the judges will refer. Again, it's not legislated, but it has become practice that they have what they call a sticker decision, which is the first time somebody shows up in small claims court. The judge says, want to try mediation? The parties are always afraid to say no, puts a sticker on the protocol. In other words, doesn't even fill out the protocol, puts in the date, signs it, referred to mediation. Those cases are then really the meat and potatoes of the training system, because, as I said, every trainee mediator needs to do 6 cases. Some do more. In my case, it's stretched out to 8, just because it did. And so those cases are referred, and then the trainee mediators are also basically trained in intake as well, because the small claims court has referred the case to mediation, and then you, as the mediator, once again under supervision, call up the parties, say, hey, the judge referred to mediation. Do you know what mediation is? You explain the advantages of mediation, all of the principles we know, consensual, confidential, et cetera, and inform them. Let's say you're not supposed to really try to convince them, because there are ethical problems with convincing people to mediate, but you're supposed to inform them and to see if they want to come to mediate. So that's small claims. And as I said before, I kind of skipped over it kind of quickly. There is a roster of small claims accredited mediators to be court appointed mediators, who are those who have just finished the basic training, the basic 120 hours of training. Under the new regulations, any case now above about 9,200 sterling is now referred to a system which I'm going to explain shortly. So you can see there's a little bit of window in there of about £2,000 where you actually don't have to mediate. It's a case that's in magistrate's court, but doesn't reach the 9,000 threshold. So there is that tiny window, but it's insignificant. And finally, family matters, as I said, that we're not actually going to be talking about. So what do the regulations require? The regulations require, basically, there are 4 touch points where mediation is either required or recommended or may be recommended. So the first in Regulation 35, I just put that in for anybody who wants to check, is there is a preliminary meeting. It's a meeting before pretrial. It's a meeting before pretrial. It has to take place 14 days after submission of the last pleading. And it takes place only with counsel, without the parties. It's not a mediation session at all. But what it is there is an obligation placed upon the 2 parties or counsel for the 2 parties to report to the court whether they have considered ADR solutions, not including arbitration, not counting arbitration, but other solutions, early evaluation or direct negotiation or mediation, whether they've considered them, and if they have rejected them, why they have rejected them. And the penalty for not supplying this report, the court can of course order you to comply with the force of a court order. It can stay proceedings until it's complied with. And if it's the plaintiff who didn't comply, who didn't go to this meeting or didn't submit this report, the suit may be dismissed without prejudice. Of course, they can resubmit it, but it can be dismissed. If the behavior was not justified, including if it was in bad faith, costs can also be awarded at this point. So it's really early on in the stage. Only the pleadings have been submitted at this point. Parties aren't involved, but this report must. But it's only a reporting obligation. Has ADR been considered? And you have to justify ADR not being considered if it was not. The second touch point is the referral to obligatory MIAM, which, as I said, I've been calling obligatory mediation, but of course it isn't. After service of the last pleading, the court will appoint a mediator within 10 days. The MIAM has to take place within 30 days. And then the MIAM has another 14 days to report. And all of this has to take place before the pretrial hearing. All of the sanctions I mentioned before are there for if a party does not show up to the MIAM. They're subject to expenses and beyond, so they can be awarded costs and all of the other things, again, up to and including dismissal of the claim. The MIAM session is 90 minutes long, and the mediator, of course, is free during this session. It can be longer, it can be shorter, but this mediation is the session is free. The parties then have to make a decision whether they decide to return to court. Mediation is no good for them, and that does happen. As I said, in 50% of the cases or so, they go back to court. May decide to proceed with the MIAM mediator themselves, the one who has been appointed by the court, under which circumstances the cost of the mediation is capped to £125 per party per hour. That's if they decide to go forward with it. In other words, that's capped. Or they can go to a private mediator by separate agreement, where, of course, the cost of the mediator is not capped, and they wind up paying their own costs there. In general, I would say among most civil mediators in Israel, it costs about $200 per side for a kind of standard mediation between small businesses or something like that. Not very large cases up to a value of 2 or 3 million, something like that would be about $200 per hour per side. I am going to jump family. I just wanted to touch on the family procedure a little bit, also because I have a little bit more time. I do have a bit more time. In family, it's a bit different. That has been settled since 2014 through legislation. I should mention before that in fact all of these procedures about submitting, about having the preliminary meeting, and about having this mandatory MIAM, the two of those things and the other touch points as well are included in the civil procedure regulations. They are regulations, they're not primary legislation, they're secondary legislation, although at the end of the day, they were approved by the Parliament as well, by the Justice Committee of the Parliament, not by the plenary. So there is some parliamentary oversight because it was a very, very big reform. So it was covered there, whereas in family, it was done by legislation. Why that is, perhaps because here it may touch actual lives of actual individuals, especially children. But in any case, that was established in legislation in 2014. What happens is, again, except for a number of specific cases, for example, where there's imminent danger to somebody, when a child has been kidnapped out of the country, when there's domestic violence at stake, and so forth, and there are those exceptions. But in general, any family case for support, child support, marital support, custody, parenting, etc., when you go to the court to submit your case, in fact, the document that you submit is a request for dispute resolution, and you submit an unspecified claim. That is to say, you say, yeah, you're suing for a change in the child custody regime, but without any sort of depth, any sort of factual or legal claims. The main thing is that you submit this request for dispute resolution, which is also a standardized form. In Israel, normally when you sue somebody, you submit a standardized form, which is actually a summons for them to appear in court, and the court administration puts a stamp on that, and then you serve it. Here, in this case, as well as that, in the family case, you also have this request for dispute resolution, which is also served as a summons on the respondent. At that point, all proceedings are stayed. It means that, and this is a peculiarity of the Israeli legal system, sometimes there's parallel jurisdiction in family matters between religious courts and between civil courts. And often if one party goes to a civil court, the other party, usually the woman, the other party, usually the man, will run to the religious courts. At any case, once this has been submitted, this request for dispute resolution, all proceedings are stayed. Nothing else can happen until the MIAMs take place. In family court, the MIAMs are a bit different from that in the civil case. First of all, there are four meetings. Second of all, they take place in a little bit more structured format. The first meeting is without counsel. Remember, the first meeting in civil matters was without parties. Here, the civil meeting is without counsel, just the two parties and a mediator who has what I would call a mental health or a therapeutic background, that is to say, a social worker or a psychologist who has been qualified as a family mediator. That's the first meeting. The second meeting is with that mediator, but is also with a legal mediator, a mediator who has a legal background, as a lawyer or a jurist, and that meeting is with counsel. So at the first meeting there are 3 people, and at the second meeting there are 6 people, basically, 1 lawyer mediator plus counsel for the parties. And again, the possibilities there after those 4 meetings, it's a maximum of 4. It's also possible for after the first meeting or after the second meeting that the mediators report back and say there's no possibility of mediating this conflict. The parties are too entrenched or whatever it is, and go to court. But they also have, once again, that choice, entering into court-appointed mediation, $125 an hour, choice of a private mediator, In my own personal case, from my own personal experience, we never even went to court. We went to the mediator first thing. We never got to that stage. We didn't want to be involved and so forth. And that was a private mediation. And the third option is, of course, going back to court, and the mediator does report on what happened in the proceedings within the bounds of a confidentiality. I want to talk about confidentiality for a little bit, and this will actually be the last subject that I really cover, and then we can open it up for. And we can open it up for questions. As I said, I'm covering also for my other partner. I think before I begin, just to touch on admissibility and privilege, and for those of you who are not lawyers, I'm sorry for going into some terms of art here because there are kind of fine legal distinctions which are involved, but I hope that the general principles will be basically clear. I mentioned that there are 4 touch points in civil proceedings, and I only mentioned 2. First is the ADR report. Second is the obligatory Menahem. The other thing is that at any point during the proceedings, and it goes back to 79C that I mentioned before, the judge can again, with the consent of the parties, refer to mediation. This is a suggestion, but anybody who has ever stood before a judge, I think, knows the general weight of a judicial suggestion. It's not something that you usually say no to. You usually go, even if you're going to mediation, and just show up. There's actually been recently some guidance on that, which I actually just came across, which says also just showing up isn't enough. You actually have to take an active part in the mediation. You can't just go there and say, okay, I hear. And in fact, the language that was used said even attentive listening. Even attentive listening is not considered active participation and can get you hit with costs. Basically, that's the bottom line. You have to go, you have to participate, and as I said, you have to consent, of course, to a judicial recommendation. But once you're in the room, you actually do have to take part. The 4th touch point, and this is a little bit new, is that not only a judge, but also what's called a legal assistant. But what's called a legal assistant is also entitled to recommend mediation. And this could be a court clerk. It could, in fact, be somebody. It could even be an articled clerk of the judge. It could be somebody doing their article saying, "Hey, you should go to mediation with this." It can pretty much be suggested by any court officer who's fulfilling a legal function. So that's also quite new. I think I should mention also at this juncture that because all of these regulations only came into force on the 1st of January this year, and of course, because of COVID restrictions, Israel's been doing well dealing with COVID up until now, not so much anymore, but still, because it was in COVID time, there hasn't been a lot of practice and there hasn't been a lot of guidance on this since. The guidance that we do have comes either out of family cases, or some civil cases. There was, I think I mentioned offhand that there was a pilot run for the past few years in only 2 courts in Israel, and the Tel Aviv District Court and the Nazareth District Court, where there was obligatory Menahem for some civil cases, and so there was some experience was garnered there. There was some guidance, and I'm going to come to that in a minute, to that guidance that we were talking about. So first, in terms of statute, and again, remember, we're talking here about privilege, and we're talking about admissibility, and these things are best regulated in statute. Of course, as in any common law system, it's subject to a lot of interpretation. There's a lot of need for judicial guidance on that, but it is, as they say, what it is. 79C, which I've mentioned a number of times, which is the mediation section of the court's law, and this is there, says that communications during the mediation process are inadmissible. So that's all that it says. That's all that it says. It doesn't say anything about immunities. It doesn't say anything about privilege. It just talks about the inadmissibility of communications. These, I think I should put in brackets at this point, that of course 79C relates only to court affiliated mediations. Private mediations are not subject to this because it's a normal contractual arrangement. Of course, there is, the common law principle that negotiations towards a settlement are not admissible. And so when you're talking about private mediation, it could fall under that doctrine. But here the statute really only speaks about affiliated court annexed mediations, which might be the required MIAM that we're talking about, but it also might be referral by a judge under his authority to recommend. I do not know why this keeps jumping forward. Once the court has referred to mediation, there is in the regulations, these are not the Civil Pro regulations, these are what are called mediation regulations, which deal with the qualifications of mediators and so forth. There's what's called the model agreement. And if you go into this, there's constructive assent to the model agreement. You can renegotiate it, of course. It's something which may be, but if you don't renegotiate it, and usually in a lot of cases, the mediator says the model agreement outlines what the provisions of the model agreement are, and in most cases the parties accept it. In most cases, also the parties are not necessarily familiar with the mediation process, so they don't really have any way to think about it. I'm not going to go into all of the provisions of the model agreement, but remember, this is also it is contractual. At the end of the day, the parties sign it and the mediator signs it. One of the elements contained there is mediator privilege. That is to say, the mediator, him or herself, cannot be called to testify in court as to what went wrong in the proceedings, or about documents or anything else. The mediator, the other side of the privilege is confidentiality, that the mediator will not disclose information which they received during the mediation to anyone who is not a party. So they can't be called to testify, and they can't use it in other proceedings and so forth. And those are the things which are contained in the regulations, which pretty much, again, there's been some litigation over that, no real guidance from a higher court about the boundaries of that. For example, questions of good faith in the report, in the mediator's report from MIAM, can they say that the mediation didn't succeed because one party acted in bad faith or not? There's some questions that's undecided at this point. That's still open to consideration. Where
Chuck,
there is case.
Chuck,
Yes.
can I just interrupt a second? If you can think about 5 minutes or so before we move on to Q&As, please.
I have 4 points there. You can see in front of you.
Okay.
That's it. That's my last slide.
All right, okay.
Right. So where there is case law, where there is guidance, is concerning whether all of those sort of rules apply in a private mediation as well, even if they're not written into the contract. So again, the first thing, the admissibility question, the court, and this is from the Supreme Court, has said that in terms of information in negotiation, information in the mediation, it's negotiation towards a settlement, and therefore it's inadmissible. As far as privilege goes, in this one case, the court did indicate that there are 4 possible grounds for privilege. Of course, the court decided there was privilege for the mediator. First is, of course, to maintain the trust of the proceedings. Secondly, to protect the privacy of the parties. Third, encouraging use of ADR. And fourth, ensuring the neutrality of the mediator. So that's the guidance that we have. That's statutory, regulatory, and case law. And as Dave so kindly reminded me, with that, I thank you for your attention, and I'm open to any questions that you may have.
Thanks very much for that, Chuck. I've seen a question posted by Will Chalmers. So can we kick off with that? But if anybody else wants to raise any questions or comments, there's in the reactions box, if you can click on raise hand, and then we can come to you that way. Thanks. Will, are you there?
Yeah, Dave, Chuck, brilliant presentation. Thank you for that. Very enlightening, actually. So that my question, Chuck, was of course, you've been speaking with a court-mandated process. It would be good to know, maybe there aren't any, but the impact on this forced viewpoint of going through that MIAM process to get to dovetail people into mediation. Has there been an impact on the private side of practice, do you think, and the general public's knowledge, understanding, and take-up of mediation?
Thanks for the question. The question is good. It's a point which I did not relate to, but it was definitely on my agenda, which is that first of all, let me put it this way, that as I said, until now, we haven't seen any decrease in backlog, but we don't know because the experiment hasn't been going on for long enough. But the question being then what the effect in terms of expanding the use of mediation, would then be. And at least for court-appointed mediators and for mediators in general, it seems that the major advantage of having this court-appointed mediation or court-appointed MIAM is that counsel is exposed to mediation. Counsel who is not aware of the advantages of mediation and the possibilities are exposed. The parties, how often do parties find themselves in court? Even commercial parties don't find themselves in court that much, if you're talking about the masses. But the normal thing that a person does when they're in a business conflict, the first thing they do is they pick up their telephone to their solicitor. And until the solicitor has been in some sort of mediation situation, they might have undergone training as a mediator, or if they've been forced into this MIAM in a previous thing, then they know that mediation is in their bag of tricks. And then they can suggest, again, even without resort to the courts, they can suggest to the client, hey, you know what, mediation is a good thing. It might be appropriate in this particular case. And that definitely is an advantage. And we see that as private mediators, that in most cases, attorneys who come to private mediation, who suggest private mediation to their clients, are those who have been forced to go there in MIAM in the first place in a different case, and then they say, okay, this is a good thing. So that's something which is good for us as mediators, I suppose. Why we should be supporting something like this as well. You don't make a lot of money, and taking cases for 125 pounds an hour is not necessarily a way to make a living, but those things could be actually kind of your loss leader for the cases that are going to bring 200, 300, and 500.
I'm searching to see if anybody's got their hand up. Chris Macon has. Roger, would you like to pose your question or comment? Are you muted, Roger?
Yes, thanks, Dave, and thanks, Chuck. Very, very interesting. Can you tell us, Chuck, what you think are the key things that we in England can learn from the Israeli experience in our journey towards compulsory mediation?
I would say that the last point I just made to Will's question is probably the main thing for us as mediators. As I said, I can't talk to the effect on the justice system in terms of backlog. That's maybe another point that I can make in terms of lessons learned, is that backlog is the way it should be promoted to the legislature. That's the way you convince Parliament that they should be mediating, not because it's a better form of justice, not because it's collaborative, not because it's empowering, not because of all of the reasons that we throw around between ourselves and our clients about mediation, but rather because it reduces backlog. as I said, empirically that can't really be proven, but that's the way to get it through Parliament. But the lesson to be taken away for us as mediators, and why it should be, why we should again be zealously promoting it, is that it gets us work. At the end of the day, again, lawyers who have been exposed, it's basically the court system is doing your marketing for you as to the advantages of mediation. Yeah, so I would say those are the two lessons learned. A sub lesson, of course, is that there is a triad here, which is in terms of obligatory mediation, it has to be accompanied by obligatory qualification, government recognized qualification, and a fee cap. So as not to run afoul also of access to justice issues. Those three things make a triad, which any system is would be wise to pay attention to.
David Watkinson wishes to speak. Dave.
Yes, I see David. David, you need to unmute yourself. Welcome.
Thank you very much, David. Thank you very much, Chuck, for that. My question kind of follows on from the answer you've just given. And it is this qualifications process that you've described. How is it set up? Was it by statute, by regulation, or how? The reason I'm asking is there's been a fair quantity of debate about the principle of compulsory mediation, but it seems to me there's been very little about the actual nuts and bolts of setting such a system up. And the Israeli experience that you've been telling us about gives us some clue as to the nuts and bolts. I can see eyebrows being raised in the mediation community about a renewable license fee that you have to pay for. Yes, that's my question.
Okay. First of all, in terms of the structure of the requirement, the requirement, again, the statutory requirement is that the court-appointed mediators would be qualified under the regulations. The regulations give some very basic outlines of that you need. You need a basic course, you need a practicum, and you know, you need the academic qualifications and the assessments. The actual nuts and bolts of, for example, the syllabus of the courses and so forth are established basically through administrative rule by the court's administration, by the judicial branch, courts administration. They're the ones who do that. Up until now, most of it has been done actually through professional committees who have involved the public side. They've involved people from the justice system, from the ministries, the relevant ministries, justice, social welfare, etc., and representatives of private mediators, mostly academics who have made a name for themselves there. So that's where those things have been established. In terms of renewable fees, look, the main thing is that, and you know, the best kept secret in the world of mediator training is that there isn't at this point enough work for everybody. There are in terms of conflicts. If every mediatable conflict would be mediated, then there would be plenty of work for us, if not twice as many as us. But in the situation the way it stands, because mediation is not the option of choice, or it isn't even well known to counsel, to solicitors, there isn't necessarily enough work. So people are willing to pay these hefty fees because they're guaranteed to be getting at least 1 or 2 cases a month, which they then may be able to roll over into paying cases, the case themselves, and then of course having that marketing opportunity. As it stands, at least according to estimates by the court system themselves, any mediator so qualified should be getting about 6 referrals a month. Once again, out of those 6, they'll be able to convert 3 of them. So it might be actually worthwhile to pay those fees. And it also is a bit self-selecting, I think, for people who really take the profession seriously.
I've got 3 people with their hands up in order that I've seen them: Jonathan Lux, Isabel Phillips, and Graham Perry. Jonathan, could you pose your question, please?
Yes. One of the main arguments, it seems to me, against mandatory mediation is that it risks making mediation a tick box exercise, which will impact upon the popularity of mediation itself. Now, Chuck, you referred to the top-down approach in Israel, starting with, I think, Supreme Court Justice Barak. What I'd ask is whether perhaps a bottom-up approach is the better one, through more widespread education, in particular of the main gatekeepers for mediation, namely the lawyers. Long term would be my suggestion. Education may be the better approach rather than trying to impose it top down. Your views, please.
Look, I mean, I'm going to give you the mediated answer, which is it's both. It has to come from both sides, I think. That is to say, I think there's a possibility. Let me put it this way. I'm also a bit involved in the mediation scene in India, and the Bar Council there, who regulates the content of legal education, has just recently included an obligation to have a basic course in ADR, and I think that exposing law students could, come the time, create that sort of pressure from underneath as well, that the law student goes and says, yeah, well, I learned about this, and maybe I took part in one of the international competitions, and mediation is a great thing, and that can create the pressure from that side. In terms of education for currently, mid-career or senior lawyers, I don't know. Again, I don't know how much you can necessarily force that. I don't see anybody making CLE or CPE requirements for existing lawyers to do an ADR course, but I'm encouraged by introduction of the newer generations of lawyers to that it may create simply that sort of awareness and that consciousness that mediation is an appropriate tool under certain circumstances, and that would help, in addition to again, as I say, the required MIAM being, at least from my point of view, from a marketing point of view, more important with the solicitors or the barristers as an audience rather than the parties. I know it's a bit cynical, but that, because they are, as you said, they are the gatekeepers. When the client picks up the phone and says to their lawyer, "What should I do?" That's the exact breaking point. So what you said about ticking off the box, of course, as I said, there was this guidance from the lower court saying you can't just show up. That doesn't cut it. And you can't even just show up and pay rapt attention. That doesn't cut it either. You really have to kind of be a part of it. That part may be arguing, but still, you have to be a part of that. So I think that goes to that question. There's no doubt that getting them young, requiring perhaps exposure to mediation techniques during legal education are important parts of the system as well. In Israel, at the very least, it's not. They're elective courses, but they're not required. I should just end with that.
Thank you.
Isabel Phillips, please, if you're ready.
Actually, Graham had his hand up before me, but not his yellow hand, his physical one. So I'll defer to him first.
Graham, do you want to go first then?
Thank you, Isabel. Not a problem. I'm quite happy to go first or second. Thank you very much, Will. A very interesting presentation. I just want to make 2 points. I suppose they're general in the sense that my concern about mediation, my concern about the training and the education, is that we are emerging as the close bedfellows of litigation and arbitration, which mindsets require and impose a very different cultural set of attitudes towards thinking about how to resolve a dispute. I'm making here a general point. My concern is that the emphasis, and this is not having a pop at you, Chuck, in any shape or form. I'm making just a general point. Do we recognize the extent to which we have to clear our heads of the culture of litigation and arbitration in order to ensure that mediation maintains that freer spirit, free of structure, free of rules and regulations, to ensure that the mediator's personality comes through in a dispute and makes it more amenable for the parties to reach a settlement. I think I'm being a bit general, but I think you'll understand what I'm saying. Are we in the grip of a legal culture which runs the risk of strangling the creative capacity of a mediator?
Perhaps. Again, I can't give you a completely straight answer. That of course is the argument against compulsory mediation, and there is an argument back and forth. It's not simply the the laziness of the legislature that mediation has not been made compulsory up until now. There is an argument. There's an actual argument. There are actually internal arguments as well about other things. For example, about the fee cap. That's also a big matter of discussion. I think the original, I think it kind of depends on what you see, the purpose of mandatory mediation as being. And in Israel, there is this tendency, in fact, I should mention this as well. And one of the articles I mentioned in my talk, or I referenced in my talk, was about this, that in Israel, there's a tendency to see commercial mediations also as a tool for case settlement, and not what we recognize normally as mediation. In other words, it's a way to help the parties split the difference. It's in that compromise part of the matrix rather than in the collaboration part of the matrix. And I think there's a lot of validity to what you say. In the Israeli reality, since mediation was seen that way anyway, encouraging that wouldn't necessarily have a backpedal on the use of mediation in the court system, but it of course would definitely be to the detriment of the practice of mediation, as you say it, and as again as we were trained to see it, in terms of value creation and interest-based solutions and so forth. So I tend to agree with you that is a danger. I presented the things, I don't take anything personally. I presented the situation as it is without expressing my personal opinion on it at all.
Thank you.
Chuck, your co-presenter has just appeared and I've let him in. He's on mute, but he may want to say hello before we're almost closing.
Hello.
You've got power again.
Just, yeah.
Would you like to say hello to Chuck and the rest of us?
I thought I just did. Hello, everyone.
All
hello,
right,
Chuck.
Okay. Chuck's already done a very, very good presentation, which I think everybody is pleased about. I'll come back to you in a second because I think we've got time for 2 more questions. Isabel, you were the next on my list.
Thank you, Dave. Just wondering, and this may or may not be something you can talk to, but my understanding from the introduction of sort of compulsory systems of various sorts in New York City and New York State, that they're one of the difficulties that's arisen there is that basically it's turned certainly the lower end lower to mid-range end of claims into a pro bono only situation around mediation, that basically people don't expect to pay for mediation at all. Do you know, or do you know enough about that context to have a sense as to whether Israel's in the route it's taken running the risk of the same thing? Or do you have any advice around that in terms of obviously that's going to be an anxiety for people if they know about the New York context, if they don't, maybe not.
Yeah. I'm aware of the New York context also because I'm a member of one of the New York Bar Associations. Besides being admitted there, I'm on the ADR committee of the New York County Lawyers Association. There are two different situations. In terms of what's going on in New York, that's a big question also of compensation for the mediators. As I think I kind of hinted, in terms of the Menahem and the magistrates courts and up, you know, there was debate, and that was debated, and that was the solution that it's come to. And still, you have quite a number of mediators who are willing to take the plunge and join that sort of list in order to make money off it. I think that. Yeah, there is a certain issue with the small claims court. First of all, I mean, it's great for the trainers because you get a massive number of cases, and you have a constant sort of cases that you can use to train people with, which is a good thing. The second, of course, if I mentioned that convincing counsel of the value of mediation is one of the goals, you don't have that in small claims court because the parties are unrepresented. So since the parties are unrepresented, you don't have that. Another question is, how often do people find themselves in small claims? In fact, at the beginning, we used to include in the mediated agreements a request for the court to return the fee because they had reached a mediated agreement, and that was kind of knocked down in the end. They still have to pay the court fee, so they are paying something, and they're getting justice from somebody. I mean, again, it's small claims court. They don't care where they're getting justice from. They may be getting it from a judge, they may be getting it from a mediator, but they're paying the same thing no matter what. Why a mediator would do it? Training purposes, definitely. There was some sort of questions of the fairness of the distribution of cases before also, where before this reform, the cases were kind of distributed in not necessarily in an equitable sort of fashion, but based on who the court's administration liked or who they knew get things done and so forth. Under the new system, that's not the case. That's not the case either. So I think under the old system, that might have been an encouragement for people to take these sort of cases as well. As if you show that you're a good camper, then you might get more cases as well, especially the higher valued cases. But there is a point there. But in point of fact, these cases are referred and they are mediated, and mediators do them. Another reason is also to get your numbers up, to get the number of cases. When you want to qualify as a district court mediator, you have to show 18 cases. You've done 6 of them only in your training. You have to get these other cases somewhere as well. And I think they're counting on those sort of things as well. It's kind of paying your dues to get in, is by mediating these pro bono cases.
I think we've got time for 2 more questions or comments. I've got Hugh Elder with his hand up, and I also think that Victoria Mitchell has posted something. Hugh, would you like to go first, please?
Thank you, and thank you, Chuck, for a great presentation. On the question of active participation in the mediation, how does that work in practice? Who decides whether somebody's sitting there and participating or not has crossed the barrier?
Right. There are 2 levels to this. First of all, in practice, how it's done is that after the Menahem has failed, or let's say the parties have decided to go back to court, and no matter what the case, no matter what the outcome is, the mediator, the court-appointed mediator, submits a report back to the bench. What happened? Again, not with an outline of what was said, confidentiality, etc., but on such and such a date it took place. The parties decided, and of course that the mediator themselves can say the person came and didn't or did, etc. There are confidentiality issues with that. I admit and I agree that the mediator has to walk a very thin line between breaching confidentiality and reporting what happened, but that's actually not very. It's not very different than saying that that somebody showed up and didn't negotiate in good faith, which is another thing. And there has been some discussion of how and when that should be reported, because if good faith or lack of good faith is the grounds for awarding costs, then it has to be reported to the bench somehow. And who can do that? Whether one of the parties can bring it up, or if that's breaching confidentiality, or if the mediator does so. It's not settled, but again, in this one case that I did mention, it was in the mediator's report. The mediator reported to the bench that this party did not actively participate.
And if one party says, well, I'm owed £1,000 and argues vociferously they're entitled to the £1,000 and won't shift a penny, would that count, do you think, as non-participation?
I don't know. I do not know. The question whether stonewalling would count as active participation or not. Again, in this case, it was a little bit more clear. The person showed up. The person was a representative of the company, showed up and said, and that's where it was given. It hasn't been expanded upon whether somebody making a ridiculous offer could be counted that way as well. But again, it's not actually it's Menahem. It's not actually the negotiation phase. Once somebody says, well, I'm offering X, and the other one says I receive it or I not receive it, actually at that point the mediator's meter is running. It's become a mediation, and they have gone into mediation. If it doesn't work out, it's a failed mediation, but it's not a failed Menahem, and that's a different story.
Thank you.
Victoria, if you're still around, Victoria Mitchell, would you like to pose your question? Maybe Victoria's gone. I'd just like to make one comment. I think Chris.
Hello?
So, Victoria?
Yes, I was asking earlier that making mediation compulsory might make some people have lose faith in the legal system, because it may compel them to concede to certain issues. Do you agree with me?
Right. Well, I think I answered that in the private chat as well, which is that if you're talking about real mediation, and if you're not talking about settlement facilitation, if you're talking about settlement facilitation, yeah, of course. But if you're talking about real mediation, that's the mediator's job. The mediator's job is to balance out power imbalances, to get real interest-based, to identify interests and needs in the mediation room. Right. So I think in a situation actually where there's a marked power imbalance, the parties are liable to come out of there with a better feeling about the system, and the system referred them to mediation rather than a worse feeling. Again, if it's the mediator's objective to get a settlement at every cost, then what you're saying is 100% correctly. But I would hope for more from our mediators.
Thank you.
Thanks. I was just going to say, I think Chris Makin put up a comment about, and I've responded in terms of saying it's the pharmacist #2 case. It was nothing to do with the amount of fees that the mediator was charging.
No, I didn't say that.
Oh, sorry, I misread it. Sorry.
No, it was a question of how much the mediator, I think she was a partner at Clyde & Co.
She was, yes, and is.
That she would charge for a court appearance, and after that the parties weren't interested.
Well,
that's what I heard.
I don't think it was quite that. The parties settled. Yep. She was ordered to appear by the judge, but it actually in her statement in brief was that she'd done 150, 200 mediations since the case. couldn't remember anything about it.
Remember, that's right.
And that if she was going to be called, then she would be expecting her time to be charged for.
I think the point, Dave, was this: that the parties to the mediation had privilege in what had happened, but both waived that privilege.
Correct. Yes.
And the Minister of Agriculture were extremely interested in what was discussed, because they wanted to use that not just as not as a precedent exactly, but as a way to handle a lot of the other farming companies who'd taken on this work of destroying the beasts after either foot and mouth or BSE, which outbreak it was. But there were funeral pyres all over the countryside at one time, getting rid of herds of cows. And so the men of Ag were very interested in what had happened on both sides, so that they could handle further discussions with other claimants. But the point was that both parties had to waive their privilege.
It waived, yes.
It was allowed to explain to a judge or indeed to anybody else what had happened.
Yeah. It was an allegation of economic coercion by the ministry.
Yeah.
Sorry, I misread your.
Well, I
your
tried
post.
to hastily. I perhaps wasn't clear.
Okay, not to worry.
It was pharmacist. You're right.
Yeah, pharmacist number 2.
Yeah.
People can look it up. It's about the only case that I know of where confidentiality has been broken by the court, as it were. So I think we've run out of time for Q&As. Thank you very much, Chuck, for that. I don't know, Paul, would you like to say something by way of goodbye?
Goodbye.
It is available on a recording within the next 7 days.
Well, I hope that the slides are self-explanatory. My fundamental point was that we've had these false storms over the years with the High Court decision, or this decision saying mediation is important, and actually a lot of them lack substance. I do wonder if the 2 High Court decisions in particular do have substance. I co-mediated on something a month or so ago, and although counsel for one side wasn't familiar with those 2 cases, he was certainly very mindful that he might be penalised in costs if he didn't. And that was, I thought, positive. I thought the B case, although it's a family case, is significant, because for once we have a pronouncement in favour of mediation from the lower courts, who seem to steadfastly sidestep it whenever possible. So whether solicitor advocates here should be balling these cases at their opponents and mentioning them in court on the question of costs, and actually using the very authoritative judgment, particularly in the Blackpool case, I wonder if people are using it when they're using it enough. The very brief facts of Blackpool Football Club employed a serial abuser as a coach. They knew about it. They claimed they didn't know about it. He was sued by one of the victims. They asked for mediation twice. They were told to sod off because we have a good defence. Blackpool refused to enter into settlement negotiations without prejudice. They rejected an offer of X thousand pounds. And when it came to court, the claimant got a lot more money, and the judge went absolutely ballistic, and he stung Blackpool for every single cent that he could. And that's meaningful. That's not just, oh, well, I really think you should have mediated, as you often get. So I do see that, and particularly the review of past authorities and open. It's a very, very well considered case to be very significant. I hope that I'm right, and that over time, and by sympathetic solicitor advocates using them, that the situation improves for us.
Thanks. Chuck has just posted his LinkedIn detail if anybody's got any questions that they want to pose to him later on. So I'd like you to thank Chuck and Paul for that matter.
However late in the day.
However late in the day, for their contribution. I've got now, I'd like to invite Isabel Phillips again, who's with the CIARB, to mention something about, I think it's the mediation symposium, is it? I think, Isabel?
Yes, that's correct. I just wanted to do a brief shout out for the annual, the Mediation Symposium, Chartered Institute of Arbitrators Mediation Symposium, which is taking place on the 7th of October. And I'll just share my screen very briefly to show you the flyer. What we're actually looking at this time is inclusion and exclusion in mediation. And as you may be aware, the Chartered Institute of Arbitrators is a global organisation. So we've got 150 countries covered amongst members. So the whole issue of inclusion and exclusion on a global scale is a really interesting question. So not just from a perspective of the UK or the US, but from countries from Kenya to India to Singapore. We've got discussions around and panel discussions around technology and mediation and how that can be used to include people in mediation, hybrid processes. So there's a lot been discussion in here about things like the boundary between facilitative and evaluative processes like mediation and arbitration. And there's a panel from people who are involved in customary processes in a range of different countries. And also a subject that's relevant to a lot of us who are here on this discussion, which is when can I be an ally to people who are being excluded? What do I actually do about this? And of course, all these things are relevant to the context of us as mediators in mediations, when we see things happening that maybe we're not comfortable with, but also as a field, what are we doing and what have we done to enable people to participate in the field of mediation, and how are we addressing exclusion? And of course, that's a very different question if you're in Indonesia than if you're in India, than if you're in somewhere in the UK beginning with I, which I can't think of, answers on a postcard. So I hope that piques the interest. Any questions, please do let me know, and I'm happy to take any questions. I'll put my email in the chat box. Feel free to drop me a line, and I'll also put the link to the website. And it'd be great to see any or all of you there. There's registration links in what I'll put in the chat right now.
Is it actually 12 hours worth?
It is actually 12 hours.
Right, okay.
We don't obviously expect you to sit there for 12 hours, but we are attempting to be inclusive in the way that we're doing it, because it's a global event. Of course, the morning hours are possible for India, Singapore, and so on. The afternoon period is possible for the States, South America. And all the sessions are going to be recorded so that you can attend them after the event, because obviously I don't expect anybody else other than us who are actually running the event to be doing the full 12 hours, because that's beyond the bounds of sanity, I'm sure. So, but there will be also an on-demand video library, and all the stuff will be available for a month after if you sign up to it. And lots of mediators from all over the globe attending, and hopefully it'll be a really interesting exchange from very, very different perspectives. And each of the panels has a range of countries. We've got one panel that includes people from India, the Ukraine and the UK, others that are Belgium, Ecuador, Nassau. So really, when I say it's international, it's seriously international. And hopefully entertainingly international as well, not just seriously, because there's a place for humour too, right?
Thanks, Isabel. And can I also ask, will Chalmers of Mediator Network to mention something about International Mediation Awareness Week?
Oh, thanks, Dave. So it's following on from Isabel's wonderful symposium going on next month. The following month, for a date for your diaries, we have a week of what we call International Mediation Awareness Week. Started last year, very well attended, and it is global. So we have a framework of events which includes keynote talks, webinars, mock mediations, meet the mediator sessions, and a panel debate at the end of the week. Everything takes place online, and it's free to attend. There are some conference VIP passes if you want to go for that, but it's all free to attend. And you can see more information on the website, which is www.imaw.org. Don't worry about jotting all the details down. Dave's very kindly going to circulate the flyer for us. But the main thing is to be aware of it, help us raise its profile, tell all your contacts about it, get involved. There'll be some details to how to register for the free events. But we are looking for support. So if you want to help us meet the mediator sessions, whatever level of experience you've got, we want to help people understand what mediation is. That's what it's about. So come and have a chat with us if you want. Go to the website and then drop us a line, and we'll help you navigate to what's best for you. Does that help, Dave?
Yeah, that's great. Thanks, Will.
No worries, and thank you again, Dave. It's brilliant.
Okay. Just quickly to mention, I've sent out a questionnaire about compulsory mediation, so hopefully you've received that. If you haven't, if you can let me know, and I'll send it to you individually rather than by round robin. The next meeting is going to be on Wednesday, the 17th of November. You probably know that meetings are on the second or third Wednesday of alternate months. The speaker is going to be David Stewart. I'm not sure what he's going to be speaking on as yet, but I'll save the date. We may bring it back to the original time of 9 o'clock in the morning. But I'll check on that as soon as I know the exact time. I'll send a save the date. I think somebody where are we? I think there's something about the slides from Chuck. Chuck, would you just like to mention about the slides?
Yeah, no, I just mentioned that I sent the slides to you.
Oh, right. I'm sorry. Okay, all right. I'm trying to do three things at the same time.
You know, if you want to send them out as follow-up, that's fine.
Well, they're going to be shown on the recording anyway, so that covers that. Yeah.
Okay, all right.
I haven't got anything else unless anybody has. So I'd just like to thank you all for attending, and hopefully see you at the next time. Bye, everybody.
Bye-bye.